Hey guys, it's Amy. Thank you so much for joining me today. I hope you're having a wonderful day as always. So I just showed you a quick couple of pictures that showed TODD MULLIS at the moment that he heard his verdict of guilty. And I just wanted to show that to everyone just to show his reaction because I saw someone who was shocked and genuinely sad when he heard the verdict of guilty. Everyone reacts differently, and you could have innocent people acting out of control. You could have guilty people acting quiet. It's all in the way they behave. But I just thought that that kind of said something, and every time I've seen the way he acts, it just leads me to the potential that the man is not guilty. So as you know, TODD MULLIS was found guilty of killing his wife, Amy Mullis, and the guilty verdict came down in November. And he is still in jail awaiting his sentencing verdict. This is pretty much unheard of as far as I understand it. Usually you have your verdict and then sentencing comes pretty quickly. So the reason I haven't talked about him is because we haven't heard anything. Not because I have changed my mind at all. I am still adamant and pushing for TODD MULLIS to have a new trial. And whether or not you believe he's innocent or you believe he's guilty, you kind of have to look at the facts, the trial, the investigation, everything that comes with it, and think about whether or not he did receive a fair trial. And I just don't believe that he did. So this hearing will be his sentencing or his chance at a new trial and at a possible verdict of not guilty. Not to say that it's going to say that he's not guilty, it's just going to give him the chance. But we've all been waiting for this hearing. So if you consider the fact of how you felt waiting to hear what happens, imagine TODD MULLIS. The man has been sitting in jail for all this time waiting for his hearing. And it's been an extremely long time. And I have to say that, maybe if you were waiting for sentencing and you knew you were going to get life in prison anyway, you wouldn't probably care as much. Jail's probably a little bit easier. It's smaller compared to prison with, tougher inmates potentially. I don't personally know, but I would imagine. So if you were just waiting to be sent to prison for the rest of your life, you probably wouldn't care that you were waiting so long. But for someone who is waiting to find out if their motion for a new trial will stand up, it's a long time. The first time the scheduling was postponed was because the defense lawyers, he had gotten a new defense team, and his representation wanted extra time so they could kind of get accustomed to the case that they were going to be dealing with and have everything ready to go so they could help their client out. So they had it postponed from the original date, but then we had some issues happen around us that caused the date to get postponed and postponed and postponed. But now we have this hearing scheduled for September of 2020. And I also believe that there's a pretty good chance that he could get a new trial. But I can't say for sure. How am I supposed to know? I'm just going by what was wrong in the first trial and what was in the documents asking for a new trial. So with that said, let's just get into that and check out the documents. Okay, here we go. This is the defense motion for new trial and motion in arrest of judgment. And this is the state of Iowa's resistance to defendant's motion for new trial and motion in arrest of judgment. Essentially, this is the state's argument against the defendant's motion for the new trial. Now let's go back to the motion for a new trial. It begins, comes now the defendant TODD Michael Mullis and hereby moves the court to grant his request that judgment be arrested and a new trial granted. In support, he states as follows. Number 1, this request and motion is made pursuant to Iowa Rule of Criminal Procedures
2.24, 2, and 3. Number 2, the defendant submits the following as grounds for new trial. 1. Prejudicial misconduct by the prosecuting attorney. During cross-examination of the defendant, Prosecutor Hughes asked the court to publish a portion of the 911 call made by the defendant as he drove his wife to a hospital. After playing a short portion of the call, she asked the defendant, "Todd, do you whisper cheating whore right there?" The defendant responded no. Prosecutor Hughes then played another portion of the 911 call. The following exchange between her and the defendant follows. I'm sure that everyone will remember this, but let's just go over it. I'm going to use question for the Q and answer for the A. So, question. Do you know what you whispered there? Answer. No. Question. Did you hear that? So I'm going to play that part one more time. The first clip is 6:53 of that second tape, and this second one is right at 7.00. Just try to listen really closely. I just want you to know if you remember what you said. Now, that actually sounds a little bit more oddly worded than I remember, but I guess that's what she said. So let's continue. 911 call played. Question. Right there, do you say, "Go to hell, cheating whore"? Answer. No. Question. So you don't hear that? Answer. No. Question. You don't hear at 6:53, cheating whore? You didn't hear that? Answer. I didn't hear that word. Question. It's right at that. After you hear a ping, you didn't hear, "Go to hell, cheating whore"? After the case was submitted to the jury, defense counsel conducted a detailed review of the 911 recording, including having it enhanced by a professional audio company. The words that the prosecutor claimed were said by the defendant do not exist. The questioning of the defendant in such a manner and asking him if he had heard words that clearly were not said was a deliberate effort to mislead the jury and thus robs the defendant of a fair trial. Such action by the prosecutor constitutes prosecutorial misconduct, not prosecutorial error. And then it lists a case study example. Now we're going to get into the next reason. Number 2, the verdict is contrary to the evidence. The guilty verdict is not supported by the evidence produced and is further undetermined by the lack of evidence that the defendant murdered his wife. The defendant submits the following in support of this claim. The defendant and his son Tristan both testified that Amy left the hog barn to go back to the house, but on the way, go to the shed to retrieve a pet carrier. Todd and Tristan remained in the hog barn together until Tristan left to go check to see why the pet carrier had not been placed at the machine shed by his mother as planned. When Tristan entered the shed, he found his mother mortally injured. Tristan testified there were only 2 short periods that he was not in eye contact with his father while they continued to work in the hog barn after Amy left. He told the jury that on 2 occasions he entered another work area of the hog barn to get a drink of water. He said these drinks were of a short duration, and when he returned to the main area of the hog barn, Todd was there continuing to work. Photos of the hog barn, the entry and exit doors, and the distance from the hog barn to the shed where Amy was found established that it would have been impossible for Todd to leave the barn, assault and kill Amy, and then returned to the hog barn without Tristan being aware of his absence. Now, I don't know if you guys have watched some of my other videos or seen any of the comments that I have made, but I have been saying this for so long. There was not enough time for this to happen. It doesn't matter how long it took for Tristan to take a cumulative amount of drinks of water that took him less than a minute to go to, because Todd would have had to leave almost right behind Amy in order to be able to get behind her and kill her. Moving on to the next issue, testimony of Deputy Heemsaith, and I apologize because I know I'm saying that wrong, established that he was unaware of what the time notation UTC on the internet search documents meant. His lack of knowledge that there would be a 5-hour difference between the time shown on the search documents and the actual time the searches were conducted causes his testimony to mislead the jury. The testimony of Deputy Heemsath, regarding who used the tablet to conduct internet searches was clearly not supported by the evidence and the topics of the searches themselves. I also talk about this quite a bit and agree that those searches could have been done by anyone else that used that tablet, and there was no way to prove who it was. And in all honesty, I thought it sounded more like something a cheating wife that lived in a small town might look up on some of those. But let's continue on. Significant forensic testing was not done because the case agent did not request that fingernail clippings from Amy's body be tested. Agent Turbitt's explanation of this failure was that this testing would not be needed based on the state's theory of the case. Amy's body showed signs of a significant struggle, a struggle in which her attacker's DNA may have been deposited under her fingernails. And yes, I agree with that absolutely. Any case or crime scene you are on, you test for any possibilities. So this just shows tunnel vision. Conclusion. Due to prosecutorial misconduct, the defendant is entitled to a new trial. Further, the lack of competent evidence makes the verdict contrary to the evidence presented at the trial. The defendant respectfully requests that the court grant his motion to arrest judgment and to grant a new trial in this matter. And then it is signed by his two amazing attorneys. Now we're going to move on to the Iowa State resistance. And this comes now the state of Iowa through Delaware County Attorney John W. Burnow and Assistant Attorney General Maureen Hughes, and in support of the state's resistance to defendant's motion for new trial and motion in arrest of judgment states. And then they go into each of the paragraphs that were submitted by the defendant and say their piece. And they do show each number, and then paragraph 1, paragraph 2, unnumbered paragraph, which with regards to the defendant's motion, that the document was not written in such proper form, and the grammar was all over the place, and it was just a mess. But I guess it got the point across. So for their first number, they say paragraph 1 of defendant's motion is admitted. Paragraph 2, defendant's motion is admitted. 3, motion is admitted. 4, paragraph 2, unnumbered paragraph number 3 of defendant's motion is either admitted nor denied for lack of information and or belief. Those are kind of throwaways. But then we get into the real information, and this is talking about the 911 call. So, 5. Paragraph 2, unnumbered paragraph 4 of defendant's motion is denied. Not only were the words alluded to by Ms. Hughes in a portion of the 911 call during cross-examination of defendant uttered, "When counsel for the state spoke with jurors after the trial, several jurors indicated that they heard even more instances where the defendant made similar derogatory remarks about his dead wife on the recording. Additionally, during closing statements, Prosecutor Hughes cautioned the jury not to take her word for what the 911 tape contained, but should listen and decide for themselves as finders of the fact what was said." Now, I think this was a big mistake on the prosecution's part because they're trying to defend what they said about the 911 call and what was supposedly said that was not easy to hear, and we have no proof of what was said. And on top of defending that, they're also adding that maybe he said more things that were derogatory. I really think that that's just adding to their points, the defense's point, and adding to the prosecution's problem. But continuing on. Number 6, paragraph 2, unnumbered paragraph 1, which speaks to the verdict not being supported by the evidence. The prosecution says, "Defendant's motion is denied as the verdict is supported by the evidence produced at trial." And then number 7, paragraph 2, unnumbered paragraph 2 of defendant's motion is denied. It matters not what defendant's counsel believes the evidence shows, but what the jury found the evidence to show, and the jury found contrary to the defendant's position. And then also with number 8, they say again the same, as well as 9, 10, 11, and 12. Finally, it says, "Wherefore, the state of Iowa prays that the court will enter an order overruling defendant's motion for new trial and motion in arrest of judgment, in that there was no prosecutorial misconduct, nor was the verdict contrary to the evidence presented at trial." It is then respectfully submitted and signed by John W. Burnow and Maureen Hughes. And that ends it for the resistance from the state. And that's it for this video. I will be coming back with another video to go over the second motion for new trial and the second resistance from the state, but I don't want to make this video any longer for today. So with that said, I'm clearly losing my voice. Thank you so much for watching, and I hope you like this video. I hope it's informative, and I hope you watch the hearing for TODD MULLIS on September 4th, 2020, and support him one way or another. Whether you believe he's innocent or guilty, he did not get a fair trial, and I think that's shown in these documents. And I will be back with the other documents, which I believe actually go into even more detail, but are far longer. And I wanted to get this out as soon as I could before the hearing, which is right around the corner. So thank you so much. Please like, share, subscribe, and of course comment. And I'll see you next time. All right, thanks guys. Bye.